jibber jab, bamboozle, nuka noozle, bippity bop, she-gall. You jibber jab, bamboozle, nuka noozle, bippity bop, she-gall. I mean, you keep on talking, but you don't know where to turn it off.
Good evening and welcome to the weekend. I'm Jon Caldara, president of the Independence Institute. You know it's a favorite topic around here, not only property rights, but how RTD is messing those up. So we decided to have the full party, bring out the old CIO table to get 4 of us around. From the Property Rights Project at the Independence Institute, Jessica Corry, thank you for joining us.
Thank you.
And Kim Snyder, thank you for being here. And your lesser half, Galen Foster, who, thank you. You guys are a great couple, and we want to tell about your story. And Bob Hoban, the suit that represents them.
That's right.
All right, let's bring it over here for just some background before we introduce this incredible couple and what they've been through. Tell me a little bit about RTD's process as they've been going through FasTracks.
Well, RTD, through voter approval, has sought to expand its light rail system across the Denver metro area. And inevitably, this has meant eminent domain or threats of eminent domain in many cases. And so what we have here with Kim and Galen's case is one sort of tiny little example of what really could be a wide-scale problem, which is that property owners, without taking an active, aggressive, lawyer-backed stance against or for their property rights, may become vulnerable to really what is predatory condemnation.
Bring it over here. This is something that you don't think about. You vote for something like FasTracks, you like the trolleys, you think it's going to be great, and the city needs this good infrastructure, and it looks pretty in the brochures. But you forget that when they're laying down the lines, they're going through people's homes, and they're taking some things that often aren't for the purposes we think, like the light rail line.
That's right.
Tell me about this.
Well, that's exactly right. The West Corridor in particular, the stations, they had planned to do transit-oriented development all over the West Corridor. There's nothing that allows RTD to do that.
Now, transit-oriented development, just so that we're on the same page,
yes,
that's having a train stop and right next to it a bunch of condos or houses and a couple shops. You know, this is so that people can throw away their cars for good, and this is a transit-oriented development.
That's right.
But RTD isn't in the housing market, are they?
They're not in the housing market. They're not in the commercial development market yet. That's what this plan was based upon, and that's what they intended to do by using eminent domain, and that's how Kim and Galen in this situation got involved, because that's what they wanted to do with that property.
And just to follow up, John, TOD, transit-oriented development, is incredibly popular with municipal governments. They sell it to taxpayers saying that we will expand our tax base by creating this highly dense urban neighborhood. People will abandon their cars. They'll be healthier, they'll shop at open-air markets, and all of us as taxpayers will benefit. It's a nice idea, but in reality in Colorado, the examples we've seen and the topic of a forthcoming paper that will be out later this summer proves definitively that TOD, when pursued by government, is a failure. We see this in Nevada, where eminent domain was all the rage a decade ago, and now what was once a neighborhood of thriving Victorian houses and community gardens is now an almost empty commercial development that has cost taxpayers at least $800,000 and brought in next to nothing when it comes to the sales tax revenue that was promised.
Eminent domain is a crucial part of the government role, in that if we're going to build a road, if we're going to build a park, if we're going to build a public school, you know, we can't ask everyone for permission. If we're building a road and one guy says, "I'm sorry, we can't," you know, I'm not selling you my house, we have the power, the government has the power to say, well, too bad, we're kicking you out of your house. We're going to give you fair market value, we'll help you move to another place, but we need to run a road through your backyard. And isn't that just what RTD is doing?
Well, if RTD limited themselves to just acquiring property for transit uses, then we wouldn't be here today. We wouldn't have this problem. But it's this overreaching, this aspect of RTD going out and trying to do development. You talked about the vote. Nobody sitting at this table, nobody in the metro area voted in 2004 on a development project. They voted on a rail project. And that's how things got mixed up.
I read the ballot language pretty damn carefully. I saw nothing about transit-oriented development. All right, let me bring it to this couple. And I've gotten to know you guys over the last couple of years, and it's been an absolute kick. We did a YouTube video which has gotten, what, 12,000 hits, talking about your home. First of all, tell me a little bit about your home, because I want to know about it. Where is it, and what does it look like?
It's on the southeast corner of 14th and Wadsworth in Lakewood. and we do the window tinting, clear bras, and then we sell the totem poles and the wooden Indians there. Moved up there about 25 years ago with little of nothing, and wound up building a real good, successful business, relationship with each other that's incredible. And with our customers, we have a customer base seriously second to none, and it's just going to be hard to replace when you've got that kind of exposure and built that there, and then they try to take you away. I feel real close to what they did to the American Indians on a small scale years ago, taking me away from the land I love.
How long have you lived at this property?
24?
25 years.
I'm going almost 25 years now. It's going to be quite the change, believe me. It's really affected my wife and I mentally and physically.
I'll bring it over to Kim. Now, first of all, it's important to know you like guys with facial hair, and I appreciate that about you.
I do.
Tell me, when you guys got together and you moved to this house, what have you changed about this home over the last 20 whatever years?
Well, we totally remodeled it to accommodate us.
Now, I'm thinking this, knowing your lifestyle. Now, this is a big, swanky Cherry Creek kind of house. You've got the moat around the front. You've got carports for the rolls. I mean, this is pretty.
No, but it's Cherry Creek to us.
How do you mean?
Well, because we did everything to our personality and to our health and just to us in general. And we never had any intention of leaving the corner, even if at some point we were going to redevelop. But getting back to the property rights thing, is that the worst thing for me is, since the kilo thing that I've had to deal with, is that you realize, the more research you do, that this is sanctioned at the highest level of government and implemented at the local level, and sanctioned in that they tie so much of the transportation money to urban redevelopment and urban renewal. And it's just wrong on so many levels, and I don't think that people really understand, and that's what Bob was talking about the voters did not vote on redevelopment, they did vote on transportation. But when you tie so much of that grant money from transportation to urban development, you get communities wanting their piece of the pie.
And just a little background there, the Kelo decision that she was talking about was a 2005 U.S. Supreme Court decision that allows governments to take private property for purposes of economic development. Now, a lot of states, the vast majority of states, in fact, reacted, including Colorado, by saying you cannot take a property for the purposes of turning it over to somebody else who can generate more tax revenue. And
the idea is, and then the Kelo case saying, here's a nice lady's house, we take that house, and instead of using it to build a road or a park or a school, we give it to somebody else, another private citizen, to build a convention center, a hotel, a restaurant, and that's going to generate more tax revenue, so we, the municipal government, we like that idea. That's
right, and this purpose, this economic redevelopment purpose, is justifiable under the U.S. Constitution's public use or public purpose requirement for any sort of taking. But what happened in Colorado after the Kelo case and after this legislation was passed to protect homeowners, we see that municipal governments and transit authorities, including RTD, are shifting their strategy. And so it's no longer, are we going to take property for purposes of economic redevelopment, urban renewal, or even blight? But now it's about transit-oriented development. And they won't tell you that. They'll say this is about the transit needs specifically, and under state law these entities can take property to put in a parking garage. But what they want to do, and what we have proof of them seeking to do long term, is not just build a parking garage, as your property is being sought for, but also to build condos and build adjacent businesses that are in direct statutory conflict with what should be being done or what is permissible here in Colorado.